Okay, thank you all for having me digitally. I did have some trouble yesterday, but who I am is Douglas Lodmell. I'm the managing partner of Lodmell & Lodmell, and we are a firm dedicated to asset protection. So I've been doing nothing but asset protection for 20 years, and it is a very interesting field that has evolved a lot, and I'm looking forward to sharing that with you today. I'm also the founder of the Asset Protection Council, and that is a network of attorneys that are really using the technology of asset protection to deliver it to your clients. So I'll tell you more about that today. But yesterday, I wanted to share that I got on this beautiful United flight. And I love flying. I'm a pilot. I had my seat. I had my book out. I'm ready to go, and off we go. We actually take off. We fly, we climb up to about 6,000 feet, and then we start circling around, and then 20 minutes later, we're back on the ground, and it looks just like this. So I don't know what happened, but I know that the fire trucks were out there, so they didn't share exactly why, but that was the end of that flight, and that is why I'm not with you today. I'm really happy to be with you digitally, though, and so let's talk about asset protection. Okay. All right, so asset protection. And I can see, at least the middle of the room, I can see pretty well. How many of your clients are actually already asking or talking about asset protection? Just like raise your hand or wave your hand. Okay, I see at least 4. Asset protection is kind of the new buzzword. And for me, it's not new, but I can tell you from an industry standpoint, it's really reached the tipping point where it has become a critical component of estate planning. It's no longer something that we just completely ignore. How I know that is clients are asking about it, and affiliate attorneys and attorneys that I work with to help them provide asset protection to their clients, they tell me the clients are walking in the door and they're saying, you know, I heard about something asset protected related. When I started this 20 years ago, no one knew what I did. They thought I was a bodyguard. They thought I was, you know, they just had no idea what asset protection meant. Today, it's become very standard language. And understanding what asset protection is, what in particular people mean by the concept asset protection trust, that's your job, is to know what those things mean so that you can guide your clients to the right solutions. And there are some great asset protection solutions out there, and there are some horrible ideas out there. And knowing the difference is really the first step, just understanding what to steer your clients away from versus what to keep them focused on. My recommendation is that you be the source of that information. Because if you're not, guess what they're going to do? They're getting on the internet, they're Googling, and they're calling me or someone else, and they're saying, hey, I saw you and I want to know. There's no reason you can't be the source of the information. And asset protection really does go up and down the chain. It can be as simple as allocating among exempt assets or as complicated as an offshore trust. And we'll talk about all that. So why does asset protection work? Well, the overwhelming reason that it works is that it stops the plaintiff's attorneys from seeing your clients as a target. I mean, it's really that simple. It's creating a barrier so that your clients just don't look like easy pickings. If your clients have, $600,000 sitting in a brokerage account with their name on it, a bunch of real estate that they rent out, all sitting in their name with nothing around it, anyone doing them is going to be very encouraged by that. They're going to say, okay, I'm going to weigh the case on one hand and I'm going to weigh the collectability on the other. The case could be weak, the collectability could be strong, and that can encourage a lawsuit. Case can be strong, the collectability can be weak, and that can discourage a lawsuit. So asset protection really focuses on the collectability side of it, and it works. Well, it works if, and let's talk about why. Really, in my mind, there's 4 things. It's got to be seen as really virtually impenetrable. In other words, they can't see it as a fake. It can't be a bluff. It's got to be skillfully managed. It really can't, asset protection, when you're using it, comes down to how you play the cards. It's kind of like a poker game. The best hand is not what wins the poker tournament or the poker hand most of the time. I think the stats are 70% of the time there is no showdown as who's got the best hand. It's how you've played the hand, how you've represented your hand, and skillfully managing your client's asset protection plan, how it's revealed, when it's revealed, all makes a huge difference in how effective it is. There can't be any obvious vulnerabilities that would encourage the other side to keep pursuing it and to create more billable hours. That defeats the point. And the fourth thing is really, these are three of the same thing, and skillfully managing it. It can't be a bluff. It's got to work. At the end of the day, if you really are, even if it's a very small percentage of the time that you're pushed to the limit and it has to work, in that percentage of the time, it really does have to work, and that's important. So what do clients want? They want it to be effective, right? They just want it to work. They want to have control of it, sometimes past the grave. They want to control everything. They don't want it to cost very much. In fact, they want it to be free, but they'll go for reasonably priced. And they do not want a bunch of compliance and maintenance. If you present something that's going to create a whole nother area of their life that they have to maintain, it's going to be distracting for them, and they're probably not going to want to do it. Okay, so what are the tools that I want to talk about today? There's really three things, and two of them you're going to be very familiar with, and one of them is going to be maybe new to some of you. Limited liability companies. So how many people use these excessively all the time? Yeah, I'm sure everybody in the room uses them all the time. They're great tools. They provide charging order protection. They separate assets from each other. They're just nice, clean, easy-to-use tools. I highly recommend them for, real estate and other assets that contain risk. Asset management limited partnership. This is like a family limited partnership. It's just drafted very specifically with asset protection in mind. How many people use a family limited partnership or limited partnerships in general? Okay, not as many. And that's normal. Most people use LLCs pretty much exclusively. Limited partnerships have their place, and they have a very good role inside of the asset protection structure, as I'll explain. And the final tool is what's become known today as the Asset Protection Trust. Has anybody in here used one, foreign or domestic? Okay, so this will be a great education because it'll really, I'm gonna define exactly what it is. Limited liability company, we already know what that is. It's great for risky assets. We separate assets into different LLCs, has charging order protection. The asset management limited partnership, similar. Holding company, we can hold other LLCs in it. We can hold their cash investment accounts in it. We typically will use Arizona for two reasons. One, we like this particular tool to be outside of their home state, so we get a diversity of jurisdiction. We require somebody pursuing this to have to deal with another jurisdiction. And Arizona, like Nevada, like Delaware, has really good charging order protection, very, very strong. And no annual maintenance fees or renewal requirements, so it's very easy to maintain. Again, minimal compliance. We can include the family, of course, and most importantly, we can include the asset protection trust inside of those asset management limited partnerships. These can be done as well to create a privacy shield around our clients' assets. They can be done without the privacy shield or with. It just depends on the client's desires and their needs. So the asset protection trust, this is really the key. This is what we'll spend today on because this is probably what you're least familiar with. In the offshore version, it can literally move the assets away from a U.S. court. It massively enhances the domestic protection that you get through the LLCs and the limited partnership. It's not limited. None of this is limited to a specific risk. So clients ask all the time, well, isn't insurance enough? Well, it's enough as long as the risk is defined in the policy that you have and it falls under the limits that you have. But there's no guarantee that either one of those things are true. So it really makes a difference when you can say to a client, it doesn't matter what the liability is. We're insuring the asset. We're literally making the asset unreachable. And so in that sense, sometimes we refer to it as net worth insurance. We're literally taking the net worth of the client, wrapping it up, and making it unreachable. And again, we can add privacy, and some clients value privacy, Some clients need privacy, some don't. So let's talk about the asset protection trust and what exactly it is. So in the industry of asset protection, the asset protection trust is, what we mean by that is that it is a self-settled spendthrift trust. So we know what a self-settled trust is. Every revocable living trust you've created is a self-settled trust. We know what a spendthrift trust is. That's when we create a trust for our children and we put spendthrift provisions saying, hey, if they marry this person, they don't get the money. If they gamble it away in Vegas, their creditors can't reach the money. All those are spendthrift provisions. What's unique about an asset protection trust is, frankly, combining those two things. Because it was thought in 30 years ago that you couldn't self-settle a spendthrift trust. We knew you could create a spendthrift trust for your children or your grandchildren, and we knew you could self-settle a revocable living trust for yourself, but nobody had thought, well, can we self-settle a trust and include spendthrift provisions? The answer today is yes, you can. And that is, by definition, what we mean when we call a trust an asset protection trust. There are other ways to protect assets using trusts, but they're not known as asset protection trusts. This is an actual asset protection trust. There are two schools of thought around asset protection trusts. One, international, and two, domestic. So talk about both. The international trust came first. This was created in 1984 by the Cook Islands Trust Act. The Cook Islands, which is the flag you see there, I'm using it as the example because it was the first jurisdiction to create a statute specifically allowing for a self-settled spendthrift trust, which, by the way, it's also a grantor trust, just like a revocable living trust. So from a tax perspective, an asset protection trust is literally a disregarded entity. It's a grantor trust. There's no tax motivation behind it. You can just imagine it's treated exactly like a revocable living trust, except for the spendthrift provisions and except for the fact that if you want to break into a Cook Islands trust, you're going to need to go down to the Cook Islands because Cook Islands is statutorily prohibited from recognizing any other court, any other jurisdiction's court orders or judicial proceedings. That's written into their statute. If you want to try to get into a trust in the Cooks, you have to start your case over from scratch. You'd have to prove that case beyond a reasonable doubt, which, as we all know, is the highest possible standard, the highest burden, the murder standard. I mean, it's very difficult to prove a case, and a civil case in particular, beyond a reasonable doubt. There are no contingent fee attorneys in the Cook Islands, so good luck trying to find an attorney that is even going to take the case. And if you do, you're going to have to pay all their fees and costs up front. Your claim is non-amendable once you file it, no amending it. So no fishing expeditions in the Cook Islands. If you do lose, which I've never seen a case win down there because of beyond a reasonable doubt, you're paying the legal fees costs of the winner, including flying a judge over from New Zealand to hear the case. So, and the statute of limitations is very short. In most instances, you're going to be too late before you even start the case to come down there and file a claim. So the bottom line is that the pros of the International Asset Protection Trust, effectiveness. I mean, they are incredibly effective. I mean, kind of ridiculously so. As long as you meet a few conditions, which is you got to get them done before you have a big major problem, and ultimately, to make them really work, you got to get the assets out of the country as well. And I'll explain how this fits together, but even real estate can be protected if it's done properly. And the biggest benefit of asset protection, we already said it, it's deterrence. It's creating a structure that a plaintiff's attorney looks at and just says, not me, man, I'm not wasting my firm's time and money on this because as strong as this case is, we're never going to collect. And I'm here to collect money. And that's what really makes it work. A Cook Islands trust, or in general an offshore asset protection trust, is effective. What are the significant cases? And I'm not going to go over each one of these. We don't have time to brief them, but they're in my material. I think if you've got the handouts that are following along so you can see them. There's three big ones: FTC versus Affordable Media, the Arlene Grant case, and then the Solo case. But effectively, I picked the three worst examples I could find. These are all three bad cases. These are cases where the facts were horrible, where really the creator of the trust, the settlers of the trust, probably should have lost their money. And in all three cases, the trust worked and protected the client's assets. None of these are my clients. I'm happy to say. I'm glad I've never had a client that's gotten a published case. My clients have all either had cases never brought, dropped, or settled on their terms. And that, again, that's the goal of asset protection. You don't really want to have a published case. But these are kind of the three big bad ones, and even in these, you can see that the trust worked. So what are the cons of the Foreign Asset Protection Trust? If it was all just good news, right, we'd all do it and every client would have one. Well, number one is the challenge of offshore. Clients are a little bit skeptical of offshore. Advisors are a little bit skeptical of offshore. Frankly, in today's world of Panama Papers and offshore being a bad word, it's not the first thing a client thinks about when he says, hey, I want to go to see my attorney to set up an offshore structure. Don't underestimate that. It's a real challenge with clients. And probably some of you are sitting there going, yeah, that's the way I feel. I don't really want to be offshore either. On top of that, you've got a compliance burden. You've got Form 3520 and 3520 each year. This is a full balance sheet disclosure, including a copy of the trust sent to the IRS. It's not that fun. It's no extra tax, but it's not a fun thing, and you have to do it every year. If you do have a foreign account, you've got the FBAR and the FACTA disclosures, which is, absolutely all account information. And for sure, asset protection should never be seen as tax planning. If you have ever heard somebody say, yeah, I'm setting up an offshore structure and it's going to save me a bunch of money in taxes, run the other way. That's not a legit structure. That's an abusive trust structure. The IRS is well aware of them, and they hate them. And you shouldn't advise clients to do that. And don't work with anybody that is advising clients that we can set up an offshore account, set up a billing company, and bill for consulting and get it offshore and not pay taxes on it. Not only is it so old school and so wrong, but it's just silly. So don't do that. And of course, with an offshore structure, you're inevitably going to have higher fees and costs. You've got an offshore trustee that you've got to deal with. You've got fewer people that can draft these. The general cost of an offshore trust typically runs between $25,000 and $50,000 to set it up for a client. It's quite expensive, somewhere between $5,000 and $10,000 a year to maintain this type of trust. Again, they're incredibly effective, and in the right circumstance, you would want to have access to it. But it's probably not something for your average guy walking in with with a business or a rental properties or a developer. Probably not going to go for an offshore trust, and that's probably not what you want to recommend them. So those are the cons, and I'll put them into our 4 categories. Control, client can't be in control if there's an offshore trust, otherwise it doesn't work. Compliance, we already talked, it's got a higher burden of compliance, IRS forms, and the costs are higher. So it's got effectiveness, yes, control, compliance, and cost, kind of no's on the offshore trust. So what about the domestic trust? I mean, these are becoming much more popular. So domestic, self-settled, spendthrift trust, that thing that we specifically defined, are newer. We created these in 1998 in Alaska. And you guys have actually a famous case from Washington with an Alaska trust. Has anybody heard of the Huber case in regard to Huber? Well, you do, and I'll talk about it in a second. There are now 17 U.S. states that have followed suit and enacted some form of domestic asset protection trust legislation. So what does that mean? Well, it means that they have copied the Cook Islands statute to a large degree, and they've attempted to say, hey, why go to the Cook Islands? Just come to Alaska or Nevada or Delaware or Tennessee or South Dakota. We can do these for you. And it sounds good. And, the question is, why not? Again, you would pair these with a limited liability company or a limited partnership, same way you would with an offshore trust. What are the good sides of that? Well, No offshore component. The client has a lot less to get comfortable with, and so do you. Minimal IRS reporting requirements. It's a domestic trust, so there's no foreign trust reporting requirements, no 3520, no offshore account, no FBAR, no FACTA disclosures, nothing. So far it's sounding really good. It's typically less expensive. I say may, it really depends on the provider, but it's normally it is less expensive. A lot of drafting softwares are now starting to include domestic asset protection trust language so that you can draft them. A lot of trust companies domestically will give you a copy of their trust, and you can draft it off of their boilerplate. So it's not that hard to create one, and probably anyone in here is competent enough to take that boilerplate and come up with a reasonable domestic asset protection trust. And of course, that makes it less expensive. There's no real compliance, so that's a good thing. The cost is probably going to be lower. That's a good thing. What are the cons? And here's where we get to the rubber meeting the road. Article 4, Section 1 of the U.S. Constitution says full faith and credit shall be granted to each state for the judicial proceedings of every other state. So we all know what that means. That's the full faith and credit clause. And what it means is that Alaska cannot disregard a judgment from Washington. They just can't. The Constitution overrides state law, so Alaska can pass a DAPT statute, but they cannot disregard a Washington judgment. What else can't they disregard? They can't disregard the federal courts or the bankruptcy courts. That overrides. And then you've got even the court inside of a state like Washington will do a conflicts of law analysis and may decide not to apply Alaska law to a trust, even though the trust itself recites Alaska law. And a Washington court may simply say, well, we don't have a DAPT statute, so we're not going to apply that, and under Washington law, there's no protection. So all these things are a pretty big deal because it effectively creates a real question mark as to the effectiveness of the trust. Add to that there's a whole list in virtually every state that has a DAPT statute of exceptions. So these are all just ways in which a court and an attorney could find a way into a domestic asset protection trust. So bottom line is the problem comes in its effectiveness. So I've listed 4 cases here. And again, I'm not going to go over them all, but they are on my website. I have full case briefs of all these on my website at assetprotectioncouncil.com. You're welcome to go there. The resources tab is unlocked. You can go in there and see all the case briefs. But I would point you to the Huber case, the second one, because it was a Washington state case. And Mr. Huber attempted to set up an Alaska DAPT, fund it, and then declare bankruptcy. And the bankruptcy court just unraveled it in about 5 seconds using 548E under the bankruptcy code. And the Alaska USA Trust Company, I don't think it took them 24 hours to turn that trust over. I mean, it was just blown right through completely immediately. All 4 of these cases are cases just like with the offshore cases that I picked. They're kind of the bad ones, but here's the difference. In the 4 domestic cases here, the trust failed completely. The assets were taken. So the difference between an offshore trust having a bad fact scenario and failing is that it doesn't actually fail. It protects the money, even though it's failed the legal system here. With a domestic trust, because of Article 4, Section 1, because the assets are still in the U.S., when a domestic asset protection trust does fail, it fails completely and the assets are lost. For me, for all the clients that I have, I can tell you that's a huge distinction. And it makes me very reluctant to set up a domestic-only asset protection trust because, frankly, I cannot vouch for the effectiveness of any of these trusts in any of these states. It's just not something you can vouch for because we have too many bad cases already. I expect a bunch more bad cases, frankly. So effectiveness, no. Control. If you think you need to give up control with an offshore trust, you have to separate your clients 3 times as hard from a domestic trust. Because if you have any chance to hope that a domestic trust may work, it would be only under the circumstances that the client was far away from any control element of the assets of the trust. Again, hard sell for the clients. Clients want control. So remember what clients want. They want effectiveness. They want control. They want the cost to be reasonable, and they want the compliance to be minimal. So the bridge trust. This is a trust that I created 20 years ago, before we even had a domestic asset protection trust statute, because I realized that there was a problem, and the problem was the offshore component was difficult for clients to accept. And yet I wanted the offshore component in the 2% of the time that my clients actually needed to use the trust. And so what I came up with was effectively a hybrid trust that crosses between a domestic trust and a foreign trust. So what a bridge trust is a foreign asset protection trust registered in a foreign jurisdiction with the full formalities of a foreign trust. But then for purposes of 7701A30E, which is the code section that defines whether a trust is foreign or domestic, we make it a domestic trust, a U.S. grantor trust. So here's the benefits. We effectively get that offshore protection with even simpler than DAP domestic simplicity. So it's a tax-neutral domestic grantor trust, just like a revocable living trust. No IRS Form 3520, 3520A, no IRS FinCEN, FACTA, FBAR disclosures, because there's no foreign accounts. You can tell your client that they can keep their money in their brokerage account here. They're not going to have to move it offshore. They're not going to have to open up foreign accounts. There's no additional IRS filing requirement because it's just a domestic grantor trust for 7701. Assets can remain in their current bank, their current brokerage. They don't really have to change their life. The name on the account is going to change. Where is it going to change? It's going to change to the limited partnership. The limited partnership is going to be then owned, one general partner by the clients, and limited partner, the trust. So we have ownership at the trust level of the limited partnership interest, and then the limited partnership is going to act as the family holding company. There's no initial foreign trustee, and this is the part, maybe it's the best feature of all, the clients can be their own trustee of the bridge trust, just like they would with a revocable living trust. So it's very, very easy for clients to understand this, to accept it, to say, yeah, that makes sense to me, and it just creates something that works for clients. So if we put it into our four-part test, is it effective? Yeah, it's effective because it becomes a fully foreign trust in the event that we have a duress event, in other words, a lawsuit. The protector declares that event of duress. At that moment, the special successor trustee in the Cook Islands inures to the position of trustee. The client is removed as trustee, and then the assets are moved offshore. So we have offshore effectiveness, but only when we need it. You know, it's like insurance. You don't make a claim when you haven't had a fire. You wait for the fire, and then you make the claim on the trust and cross the bridge. The control element we meet because we can allow the clients to be that initial trustee. Cost, it's very reasonable in the context of asset protection. I charge $23,000 for the bridge trust, and again, that's right underneath the full offshore protection level, and something that I find no pushback from most clients, especially because we're protecting typically $1 to $5 million is kind of the sweet spot for where clients are most sensitive about losing their assets, versus you know, the very wealthy are frankly less sensitive than the clients we have that are in the $1 to $5 million net worth range. And compliance, there's none. Unless we have to trigger it, there's no 3520, no other compliance requirements. So let's put it all together so you guys can see how it works. The asset management limited partnership is in the center. That's going to be the holding company for the client's assets. What's going to go in there? The LLCs. So the LLCs are these little houses, and we put real estate in there. We put their toys in there, their boats. We put their airplanes, their businesses, whatever it may be. Then we have the bridge trust, and we're still going to use a revocable living trust. That's still part of the plan. So the way it connects together is that the LLCs, the little houses in the lower left, are going to be owned often single member by the limited partnership. This reduces the tax return compliance requirement. If they're single member, they don't have their own tax return. What else goes in there is cash, stocks, bonds, collectibles, coins, anything that we consider a safe asset, doesn't have risk like real estate, which would need an LLC first. And then we look at who controls it. Who controls it is the client. They're the general partner, so they're the controlling partner. They can either do that directly or through another LLC. Depends on the case, and we look at it case by case. Who's the limited partner? The bridge trust. So let's call it 2% husband and wife, each general partner for 1%, and bridge trust 98%. So one of two things is going to happen here. Either the clients die, at which point all of the assets are still going to pass down and through the revocable living trust. Or, and when it does, you're going to distribute those assets, you're going to maximize your state tax exemptions, you're going to avoid probate, smoothly pass the estate. It's going to be very much like the way you're used to seeing it now. Or we're going to have some kind of crisis event. In the crisis event, the assets move from the partnership into the bridge trust, since it already owns 98%. And at that point, the trust can literally take the assets offshore. And at that point, yeah, we are talking about offshore accounts, leveraging the equity out of real estate that was in those LLCs, et cetera. So that's the fundamental structure. That's the world of asset protection as it's become known today. And I hope that presenting the kind of the history of asset protection, of how it developed, gives you a sense of where it is today. I can tell you today, we just added another state as a domestic asset protection trust state. I think we're going to continue to see a lot more states come online as domestic asset protection trust states. I think we are, they have their use, but they are, as we've seen in the case law, limited as to their predictability. And that's the problem, is the predictability of the trust in the domestic context. The bridge trust for me offers that balance of both. But you know, even my encouragement to you would be, one way or another, start figuring out how asset protection fits into your current practice, because it is a great practice area. Even if you're doing the domestic component of it, the LLCs and limited partnerships, it's a great estate planning tool that doubles as an asset protection tool, especially when drafted with asset protection in mind, putting real restrictions on the ownership and transferability of shares, and really using all the creditor exemptions and restrictions that you can. And the asset protection trust is critical to understand it. If it hasn't started coming up in your practice, I'm almost guaranteeing that it's going to start coming up in your practice. I know you guys are out there in a different part of the world, but I think ultimately everything gets around everywhere, and the internet has made it completely flat. I mean, clients can get on the internet and learn about anything and everything from, you know, their house in the middle of the night. So they will be asking about this. They're going to want to know, if, you know, what is this offshore trust? What is this domestic trust? And most often they're going to be asking once they've had some kind of problem. You know, they've either gotten sued, they've gotten a demand letter, they fired somebody who walked out saying, I'm going to sue you. You know, they had a bad result in their business or in their practice, or something happened. That's usually when they start looking. I can tell you we do a fraudulent conveyance analysis on each client before we accept them. Fraudulent conveyance is a complicated area, but it's simple enough. If a client is doing a transfer with an intent to delay, hinder, or defraud a creditor, the transfer could be deemed fraudulent. It's not fraud, as you know, in the terminology that we're used to saying fraud. It's really an improper conveyance. California just renamed their fraudulent statute voidable transactions. It's a much better name, but it's also a much more aggressive statute. So if you have California clients, be particularly aware of how important the fraudulent conveyance component of this is. One of the questions I get a lot is, Doug, what you said was you could set up this structure where you could transfer assets offshore after a client has a problem or a lawsuit. Isn't that by definition fraudulent transfer? You're transferring assets after you have a lawsuit? And that's a great question. The answer is no, because the transfer they're referring to in a fraudulent transfer context is the transfer of title, the ownership transfer. So when you transfer the asset, when you put it into the trust, in other words, when you fund the trust, that's the transfers. When you fund the trust, you've made the transfer. When you later have the trust determine that I actually want to use a bank in Switzerland and not a bank in Washington to hold my already transferred in assets from 5 years ago, that's not a transfer under the fraudulent transfer context. That's just a change in location, a change in how you hold your assets. And that distinction is obviously critical here. The planning, all of this planning needs to be set up as soon as possible. I tell clients, it gets stronger with age. It's more effective the longer it's been in place, and you have fewer and fewer arguments against it if it's been set up 5 years ago before you ever knew this plaintiff who's now suing you, than if you set it up 5 minutes ago after you got notice of a lawsuit. So I think we're up in time, right? Isn't it?
Yeah.
So
Yes.
Everybody's got my information. If you passed it out, what I sent, please, everybody is welcome to call me. When you work with us, you work just with me directly when it comes to the attorney side of it. So you're all welcome to call me. My direct email is just my name, Doug, D-O-U-G, @lodmel.com. And I encourage you to call me. We can set up 15 minutes or half an hour to just talk about in detail how this might work for you or how asset protection in general. You're welcome to call me. Is anybody going to New Orleans this year for the national convention? Okay, so I'll be there. I'll be speaking on the main stage there as a keynote. So you can let me know you're coming, and we can set up a time to talk, or you can just grab me when I'm there, and we'll chat. But again, I appreciate it. Thanks for making the digital version of this work. I'm really glad it still works, even though I couldn't be there in person. And if there's any other questions, I'm happy to answer. Otherwise, thank you for having me.
Thank you so much.